Viewers, after a tumultuous 2 months, the Karnataka High Court has given what many people have described is a studied verdict on the hijab issue. The High Court bench came out and said that the wearing of the hijab is not essential to the practice of the Islamic faith. Hijab is recommended but not mandatory. But the petitioners' viewers, as is to be expected, are disappointed, and they have decided to appeal in the Supreme Court. The top court has said it will look into this entire issue after the holy vacation, and we are told that perhaps as early as Monday, a hearing is going to take place on deciding the maintainability of the appeal. Many within the legal fraternity believe, viewers, that this special leave petition that has been filed has legal standing and has made arguments that could result in the Supreme Court overruling the High Court bench. There are others, of course, who say that the High Court went into all the nuances, framed the right 4 questions, and gave some very robust reasons for deciding in favor of the pre-universities that ruled against anyone entering the classroom with a visible religious marker. Now, viewers, obviously, the debate is set up, and I would very quickly want to sum up the arguments that the Supreme Court is besieged by. The first argument is the Education Act doesn't confer any power to the state to ban wearing of the hijab. So the state cannot do this. The legal system recognizes wearing/carrying of religious symbols. Wearing a hijab, protected under the right to conscience under Article 25. Hearing a hijab, also protected under the right to privacy and freedom of expression. The High Court, the petitioners ever in the Supreme Court, failed to address shifting of blame by the state in the maintenance of law and order. Now, viewers, these are some of the arguments that if the Supreme Court decides are worthy enough to hear, they will probably look to decide upon. But let's try to analyze the basic question, whether the petitioners have a case or not as they go up in appeal against the High Court bench. And to discuss this, we have with us Aryama Sundaram, Senior Advocate, Salman Khurshid, author and former Minister of Law in the UPA government. He held other portfolios also. Sai Deepak, Advocate of the Supreme Court, and Nizam Pasha, another advocate, join us. Now, I want to first begin with you, Mr. Sai Deepak, and I want to ask you certain questions based on a close reading of the arguments that were made and the conclusions that were drawn by the High Court. Niba Naz, a petitioner, has argued that the High Court has failed to note that the Indian legal system explicitly recognizes the wearing/carrying of religious symbols and cited that Section 129 of the Motor Vehicles Act 1988 exempts turban-wearing Sikhs from wearing a helmet, and also the rules made by the Ministry of Civil Aviation allow Sikhs to carry kirpans onto an aircraft. Wouldn't you agree that these arguments add to the merit of the petitioner's case as they approach the Supreme Court?
So, with there being senior members from the bar as part of this particular panel, ideally I think you should have started with the senior counsels. But since you have chosen to start with me, here's my submission. One, I think whether or not one agrees with the outcome of the Karnataka High Court, on the face of it, there are certainly important legal questions which perhaps need some kind of a clarification from the Supreme Court. This is not to say that I disagree with the outcome of the Karnataka High Court. All I'm saying is that it certainly raises questions which the Supreme Court must certainly consider because obviously this has a bearing on quite a few important questions of law of constitutional significance, including the application of the ERP test or the Essential Religious Practices test. Now, with respect to the question that you have specifically asked, one, the Kirpan exception is specifically to be found in the Constitution itself. And as far as, let's say, the turban exception for the Sikhs is concerned, it is long established that this is an essential aspect of their religion. Now, since the petitioners in this case have failed to prove the essentiality of hijab as far as the Islamic faith is concerned, on the face of it, the comparison is wrong. But let me just make one important caveat. As someone who's participated and who continues to be a part of the Sabarimala case, in principle, my question has always been whether a secular court is trained to look into aspects of religion. But as long as the Supreme Court continues to apply the ERP test across the board, high courts have no other option but to follow the law laid down by the Supreme Court. Therefore, while I may have in principle issues with the application of the ERP test, which is a religious examination by a secular court, the difference is, in this case, the court has applied this test with respect to a secular institution, whereas in Sabarimala, it was with respect to a religious institution. So my position is, in this case, the court could have arrived at the very same conclusion without even applying the ERP test, but to add to its reasoning, so to speak, the petitioners have also failed to establish the essentiality of hijab as far as the Islamic faith is concerned. Be that as it may, I am not going to say that this petition is fundamentally unmaintainable in the Supreme Court. I will only say that the threshold or the burden on the petitioners at this point is higher, simply because the judgment of the High Court is fairly clear and reasoned. That's all I have to say.
Okay, interesting. And that's one of the reasons I began with you, because I know you have a slightly different position, given your background as having argued extensively in the Sabarimala matter. Mr. Khurshid and Mr. Aryama Sundaram, let me come out to you, Mr. Khurshid. The Karnataka High Court has upheld that secularism is a basic structure of the Constitution. And the court has articulated this decision on the grounds of secularism being part of the basic structure of the Constitution and the country having no state religion. Also highlights constitutional duties of citizens, which includes transcending religious, linguistic, regional or sectional diversities to renounce practices derogatory to the dignity of women, unquote. I'm quoting straight out of the judgment here. The court says that this spirit is captured in the Karnataka Education Act of 1983. Given this, what do you make, therefore, of the challenge?
Well, I agree with Sai that this is an important enough area of law which concerns many citizens across the board for us to have a pronouncement by the Supreme Court of the country. And we will all await that pronouncement anxiously. Clearly, if the matter is before the Supreme Court, there are limits to how much we should be discussing it out in open. But some degree of response and reaction to what the High Court has said perhaps is justified. As long as the High Court order stands, that is the law. We have to simply accept it, but subject, of course, to what the Supreme Court will finally say. Now, I think just very quickly, a couple of points. The issue of burden to prove that something is essential practice, and whether hijab is an essential practice. I think this is somewhat misplaced. These are not civil proceedings where burden of proof and evidence has to be called. This has to be culled out of the doctrines and the understanding of a religion itself. And I think, therefore, I would imagine that that's perhaps the wrong focus. The other point about secularism is extremely important. Good thing that the High Court has very clearly upheld what the Supreme Court has repeatedly said about the secular character of the country. And I think the High Court has said some wonderful things about it. But obviously there will be a problem, and has always been a problem, about the application of secular values as to what that means in practical terms. And that's what this case is about. what is a secular value. Not wearing a hijab is upholding of secular values, or wearing of a hijab is upholding of secular values. So I think that's a very, very important area of constitutional adjudication that we have to see in due course. Finally, the issue about something that is derogatory to women is again something on which we cannot disagree. But whether the choice is a derogatory thing is a little bit worrisome. That giving someone a choice makes it derogatory. If it was imposed, I can understand that you could link it with something that is derogatory, but something that is a choice to be exercised freely, depending on what the person feels about that choice, I'm not quite sure would be justifiably linked with being derogatory. I think those are the few points that I can make.
On this point, I just want to come back to you, Mr. Khurshid, on the point of what is derogatory or not. Many women activists, feminists, if you like, have said that the instrumentality of the hijab is laid down by men. It's decided primarily by men to constrain the agency of women. And therefore, where is the question of choice here when it has been laid down very paternalistically by men for women to follow? So, I mean, I'm just saying this is what has come up in a couple of debates.
Sorry, I can understand, and this is a point of view that women have, and this could well be a point of view that liberal persons can have. There's no doubt about it. But that's why this debate and that's why this adjudication is necessary. To expect that thousands of people or any number of people who choose to wear hijab and who insist on wearing hijab are actually indoctrinated or dictated to or being pressurized or forced to do this, I think is a little bit of an outlandish thing to say, frankly, outlandish thing to say. And I do believe that none of us have a right to be paternalistic. You can't decide what I should do and what is better for me, or what is good for me. I think that's fundamentally against the very idea of a liberal way of life. And therefore, I would just leave it at that. It's a little bit paternalistic, and paternalism is directly contrary to the liberal way of life.
It's interesting because Malala Yousafzai, who of course has won the Nobel Peace Prize, had once said so. Nonetheless, let's open this up. Mr. Aryama Sundaram, now I just want you to, I want to draw your attention to what the Karnataka High Court had cited by the way of precedent. In its 129-page judgment, it cited the example of the Landmark Shera Banu case and held that what is made recommendatory by the Holy Quran cannot be metamorphosed into a mandatory dicta by a hadith. Would you say that it is highly unlikely that the judges of the Supreme Court will ignore the strong precedents set or cited by the High Court in this matter?
Rahul, let me say straight away, I am not going to comment at all on what is before the Supreme Court, pending before the Supreme Court, or am going to second guess what the judges of the Supreme Court may or may not feel about the judgment. But what I do want to do is to tell you generally in very simple terms. According to me, this matter can be complicated into various intricacies. But in my view, it is a very simple issue. The issue, if I can put it as simply as possible, it's this. There is one legal aspect to the question. There is one socio-political aspect to the question. The legal aspect to the question is basically this, that India is a secular country and secularism is a basic structure of our constitution, is beyond any dispute. That's well laid down. We are a secular country. Secularism is the basic structure of our constitution. That religious freedom is a fundamental right, strictly and jealously protected, and will be protected by the courts, is again beyond any dispute. If it is an issue of religious freedom, if it's an issue of secularism, the courts will protect it without a doubt. So the question therefore boils down to this: is a school uniform which states what kind of uniform a student can wear, is that an affront against secularism? Is that a violation of a person's fundamental right to freedom of religion? The only way you can answer that is if what the school has directed is a direct affront, to the secular way of life. What the school demands of you is a direct affront to your right to religious freedom. To show that, you must show that it is essence to your very religion. The fact that a religion may require modesty to be shown among the followers of the religion, may require the followers of the religion to dress modestly, behave modestly, act modestly, is one thing. But is it a practice which is essential to the practice of the religion itself? That is the question. The problem has really arisen whether the state should have entered this entire debate, should have entered this dispute and then passed a dicta that students shall comply with A, B, C, D, E. According to me, if a school had insisted on it and a student had objected to it, the student had a choice not to go to the school. Or if the student wanted to go to court against what the school was doing, they'd have to show that their fundamental right was being affected in some way. That's why I said there are two aspects. There's a legal aspect where, according to me, this may not have escalated into what it did if the government had not got into the act and come out with its vociferous support of all this, which then led to a political issue, it led to a social issue, it led to various issues. But according to me, it did not really lead to a religious issue. And I think what the court was faced with was a question of not whether this was socially correct or politically correct or otherwise. The court was only concerned with whether it was legally correct for a school to dictate the uniform a student must wear. And unless the school was doing something so arbitrary or unconstitutional, the court would not find a reason to have interfered with it, which the Karnataka High Court did not. I don't want to go into other comments made by the High Court about derogative, etc., etc. I don't go there at all. But all I'm saying is, what it really boils down to is one simple question: is the wearing of the hijab essential to the practice of Islam? And if so, does a person not wearing the hijab not follow the tenets or the diktats or the scriptures or the rules of their religion? Not the social aspect of the religion, not even recommendatory, as in people shall dress modestly, for example, but whether it really affects the practice of the religion per se. And I believe that would always be the test. And I believe, in a way, the Karnataka High Court tried to deal with that test. Beyond that, I don't want to comment.
Well, some people, of course, have questioned the very formulation of the questions that were therefore then decided upon. So let me open this up further. Nizam Pasha is also there with us. Nizam Pasha, I just want to ask you this, because the court has emphasized, and I'm talking about a slightly different aspect, the court has emphasized upon the fact that the right to wear the hijab under Article 19 and Article 25 are not absolute rights and susceptible to reasonable restrictions. Now, what are your concerns regarding this interpretation of the Karnataka High Court? Because a number of people who came out to react said, okay, for a moment, forget about whether this is ERP or not, or whether the court should even be getting into an issue like this. Let's look at the other issue, that the judgment itself violates Article 19 and Article 25. Court says, no, they're not absolute.
So see, again, I'll also disclaim that since I am likely to be in court, I am not going to comment on the judgment itself. But I will respond to some of the things which have been said here and some of the things which are being said. Now, all of this boils down to, if you ask the wrong question, you will get the wrong answer. So if you take, for instance, if you take the example of convent school that Mr. Sundaram was doing, a convent school is a minority education institution of another religion. So for somebody to demand practice of in that institution is going to be incongruous, and therefore the example really leads to the conclusion that is being arrived at. Now, the wrong question that I'm saying is that if you start with the question, is this essential to the practice of Islam?
I have to interrupt you only to say this, that I did not study in a convent school. I studied in a secular school under the central government. I studied in a secular school. I gave an example of the convent schools, but I studied in a secular school which had a uniform.
Absolutely. I'm sorry if I was misunderstood. I wasn't talking about what school Mr. Sundaram studied. I just said that, for instance, if you take the example of a convent school, that example will lead to the conclusion that is being arrived at. And therefore, it's the schools in question were government schools. And we are talking about the state and its responsibility to safeguard public places and the right to practice religion. And therefore, what I began with, if you ask a wrong question, is wearing a hijab essential to the practice of Islam? I feel is the wrong question to begin with. Rahul, you started with saying that Karnataka has a rule that any person who has any visible religious symbol in a classroom is thought to be prohibited by the state. That is not true, because an exception is being carved out for Sikhs. So, and that really leads to the answer to all the questions which are being posed about uniformity, about discipline, of why a uniform is required. Uniformity, discipline, keeping religion out of the classroom, children of a tender age, etc. Other children will feel either less or left out. And each of us has been to a school where there has been a Sikh boy, except of course if it's an all-girls school, each of them been in a classroom where there has been a Sikh student wearing a turban. Does that break down uniformity? Does that break down discipline? Does that keep that bringing religion into the classroom? Does that create a problem? Do other children feel left out? Do other Sikh children who don't wear a turban feel inferior? So in the Indian context, because we are not practicing what France is practicing, we are not saying nobody can wear anything. We are saying Muslims cannot wear a hijab. And that, I feel, is really at the heart of the matter. You don't begin with, is this essential to the practice of Islam? You begin with, who is it offending? What is the problem this is creating? In India, we have a time and tried and tested formulation that religion in the classroom, for all of these reasons, has been tested and found to not offend any of these things. There is nothing wrong with wearing a uniform. In fact, again, that's also I want to clarify. The question posed of is prescribing a uniform legal or constitutional is the wrong question. Because at no stage were the girls saying we will not wear a uniform. They are saying we will wear something in addition to a uniform. So again, to take the example of Sikhs, I went to an all-boys school. We used to all have a uniform, and one of the colors of the uniform would always have to be the color that the Sikh student wore on his turban. That was the extent of respect for the uniform that we here too, because this was in addition to the uniform, not in derogation from it. So to say, is uniform constitutional? That was one of the questions which was legally framed and answered. Nobody is saying a uniform is unconstitutional or you can't prescribe. But can I wear something in addition to the uniform, which my religion and my conscience and my right to freedom of expression, my privacy, all of them demand that I wear? Can somebody else ask this question, is it essential to your religion, without first answering the question, where is the problem being created? What is the offense? What other right is being violated? What is the unconstitutionality?
Okay. Sai Deepak, I saw you raising your hand. Would you like to come in here?
See, I think there must be some kind of clarity as to the context. So to that extent, I don't disagree with Mr. Pasha. So if you look at the first two paragraphs of the judgment, Rahulji, it's very clear that the petitions have been filed with respect to government institutions. And the notification of 9th of February or 5th of February 2022 of the government does not ban hijab. There is no such thing in that particular notification at all. It comes out with 4 different situations. One, insofar as a government institution is concerned, the government shall reserve the right to prescribe what is the uniform. For a private institution, the management will do that. For certain other institutions, there is a committee, a student committee, so to speak, or a Department of Education committee. And where there is no dress code prescribed, then the dress code shall be consistent with equality and integrity, is what it basically says. In the question, as far as the facts of this case is concerned, you specifically have 2 government institutions from Udupi, and the petitioners were from that particular institution. So the question that was being put was, does the government have the power to prescribe a uniform? And when you speak of a uniform, you're also asking yourself, what is the purpose behind the prescription of a uniform? One is that there is no class difference between students, so that they are not conscious of what kind of walk of life they come from, whether they come from a middle class society or a high class society. That shouldn't be there. That's one. Second, do you preserve the limited secular aspect of visibility, at least within the classroom? So the court answers this question effectively to say, one, the government certainly has the power insofar as its institutions are concerned. And second, the purpose is not just with respect to social status, but is also with respect to religious symbols. And the only exception that can be made to this particular rule is if you're able to show that the symbol that you wish to adorn over and above the uniform is essential to the practice of your faith. Therefore, that exception is carved out as far as the Sikhs are concerned. But the one thing that I certainly would like to agree, as far as Mr. Pasha is concerned, is this. If somebody were to ask me, in the absence of the rule, what is the harm being caused when somebody wears a religious symbol? I would say, as long as everybody has the freedom, seriously, I don't see the harm. But if the government chooses to exercise its discretion to basically say, we would want to adopt a certain policy, at least insofar as the classroom is concerned, that power of the government cannot be taken away, nor can it be questioned. And therefore, for anyone to be able to tide over that particular power, so to speak, or to say that your application of your power, there is an exception, and that exception is what I wish to wear is essential to the practice of my faith, as long as you're not able to satisfy that, then it may be a serious problem to then continue to ask this harm question. What is the harm being caused? What is the harm being caused? But there is one important aspect of this particular issue which nobody has answered, and I think it's extremely serious, which is, I'm not saying that the petitioners don't have a right to challenge the rule at any point of time, but the court is very clear that a rule that has been in existence since 1995 was neither questioned nor challenged, nor its application basically accused of bias, so to speak, and nobody has actually proved that this particular rule was exclusively being applied only insofar as Muslims are concerned or hijab is concerned. That is an issue that has never arisen from 1995 till December 2021. Be that as it may, regardless of whatever the trigger may be, I am very clear that there are certain legal questions which merit an answer. As I said, this is not a straightforward issue. There are multiple ifs and buts, but on the face of it, the High Court has not done anything that translates to infraction of anybody's religious rights, because applying a well-settled principle of essential religious practices test, it was for the petitioners to establish that despite a rule and despite a power, they have the right to wear this because this is an essential practice. Unfortunately, they have not been able to do so. Let us see if they're able to convince the Supreme Court otherwise.
Let me bring in Salman Khurshid on this. Sorry, was anyone wanting to...
I was just saying, can I very quickly respond to that?
Yeah, of course. Yes, Mr. Pasha. Yes.
So as far as the fact that this rule has been in existence since 1995 is concerned, again, the same problem. 1995 rule says that a uniform may be prescribed. Nobody is challenging prescription of a uniform. That is why it was never challenged, because till February 2022, there was no rule saying you can't wear a hijab. The second thing, that the government's prescription itself is innocuous. It just says that's the prescribed uniform. That is not correct, because the recitals of the GO say that for these reasons, a hijab is not essential to the practice of Islam. Now you go ahead and decide what the uniform should be. So you've sort of already laid the ground of what can be prescribed. So the government GO is the problem, because it gives a finding on essentiality. And the third and the last thing, on ERP itself, so I don't actually, it was a longer conversation. I didn't want to run away from the question of whether or not it is essential. Some of the things which are being said to question its essentiality are actually absurd. For example, to say that the cover of the head is not prescribed in the Quran. Now, to use an analogy of what the verse in the Quran says, because it says, use your khimar to cover your chest. That's like, for a Hindi speaker, it'll be easier to understand if you say that take your ghungat and cover your chest also with it. And for the person listening to ask, nobody mentioned covering head. The ghungat where it's lying behind you, pull it before you to also cover your chest. So that's part of the word ghungat itself. So the Quran has it, the Hadith has it, because in the Hadith also, when this verse was revealed, the women around at that time took aprons, bed covers, etc., and covered their heads and faces. So it is very essential to the practice of religion for Muslims. And again, whether or not any punishment is prescribed is a wrong question to ask, because namaz is integral to the practice of Islam. If you don't offer namaz, is there a punishment prescribed in the Quran? No.
Okay.
For all things spiritual, there is no temporal punishment that is prescribed. that is something that you will have to go and face your maker on. So you'll find any number of people not wearing the hijab, just like you have some Sikhs who don't cover their hair. That doesn't change the rule. And there is no religious, there is no punishment in the world that you're going to face, because the religion is about the hereafter.
Okay. Well, Mr. Pasha, look, I can only go by the judgment, and the judgment claims that the petitioners could not make a case to establish that the hijab was essential to the practice of the religion. They said they were woefully inadequate in supplying information. So I don't know what was relied upon. I'm not going to even go in there. I'm sure if there are what you suggest are very reasonable observations in the hadith, etc., that make it essential, then the Supreme Court, I'm sure, will be apprised of those. But I just want to expand this a little bit, because if we were to move away from the essential ERP argument, Mr. Khurshid, and my last question to you before I wind this up, there is also a lot of conversation around whether this particular judgment violates the tenets of Article 19 and Article 25.
Well, I mean, I think that as far as 25 is concerned, your discussion thus far has already taken care of 25.
Yeah.
Because 25 is about religious practices.
Sure.
But 19 and 21, I assume,
yeah, 20,
is what you're
21.
asking.
Yes,
because
sorry.
they've held against the petitioners on 19 and 21, essentially saying that 19 has restrictions which are reasonable. Reasonable restrictions can be imposed. Now, reasonable restrictions can be imposed, and that would be read into 21 as well, in a sense, although 21 doesn't have that, but it would be read in a package, etc. The issue really is this reasonable? There is no test put down in this judgment of how to arrive at what is reasonable. It's not a subjective reasonableness, it has to be an objective reasonableness. But be that as it may, I think on the issue of 19, what you've asked me, or 19 read with 21, we'll have to look at, the Supreme Court will have to look at, is what are the contours of reasonable restriction. You can understand reasonable when it means that you have to weigh the rights of one individual against the rights of another individual, or the rights of one individual causing harm to another individual. Now, we've just discussed that there is no real finding as far as harm is concerned. And if there is no harm, would there still be reasonable restrictions? Other than harm, can there be reasonable restrictions in terms of desire, want, or a preferred sense of uniformity? All that will have to be considered by the Supreme Court.
Well, viewers, fascinating discussion. Thank you very much. The panel has provided deep insights. Obviously, we don't want to presage what the Supreme Court might do or might not do. This is not an attempt to influence the Supreme Court in any which way, but the matter is obviously a complicated one, and it might see protracted arguments unfolding over the weeks ahead. We leave it at that. Take a short break. We'll be right back. Thank you very much.